Today, we're going to talk about changing the unchangeable in estate planning. I'm 𝗬𝗲𝗃 of 𝗬𝗵𝗏 Law, an estate planning firm in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you're seeking assistance in either estate planning or probate administration in New York and New Jersey, you can reach us for a free consultation at yourplanningattorney.com. And speaking of value, we're here to educate everyone for free. So please ask your questions and share so together we can help some folks along the way. Now, everyone seems to think that an irrevocable trust cannot be changed. This is not true, right? Granted, you shouldn't enter into a contractual agreement saying you want to change the terms because it was set up with some purpose in the first place, right? Like asset protection. You never want to create that irrevocable trust because it does have some restrictions. If, say, you know that you might want to change the beneficiaries in a few years, right? Like that just doesn't make any sense. You want to be pretty set on your terms. However, if the family or financial circumstances change significantly enough, right, or even if there's changes in the law, then an irrevocable trust can be tweaked, right? There's a few ways to go about this. First, it can be accomplished through basically the trust drafting with proper authorities. For instance, the grantor or the creator of the trust may be able to make adjustments like adding beneficiaries if they're given a power from an outside independent party. So you see there could be several steps to get you to your goal, but it is feasible if the trust is created and has those points of flexibility, excuse me, in the drafting. I gotta take a sip, sorry. Outside of the provisions within the trust itself, some states have strong decanting statutes that allow for certain changes based on the powers under the trust. Okay, what does that mean? For New York, for instance, if there's enough authority with regard to the distribution, right, the movement of the income and principal of the trust, the trustee can add protections for, say, the beneficiaries, right, if they weren't initially provided in the first place. Like, we have done this several times where the trust that came to us for the beneficiaries was going to be received outright, meaning a check in hand. That offers no protections to the beneficiaries. And so we helped the family sort of massage the trust through the decanting laws here in New York to then provide them with protection throughout their lifetime from any creditors, which is a huge benefit. And lastly, there are states, of course, that say with agreement by all parties, right? This is the creator of the trust, the trustees, all the beneficiaries. If everybody comes together and says, okay, we want to make this change, again, based on state law, then it's possible, right? But this can get a little tricky if some of those beneficiaries or alternate beneficiaries are minor children. That creates a headache because their interest is different from even their parents' interest, right? So how do we go about that? What does the state law say? And if there is not enough flexibility within the trust or state law to make those changes, we end up having to appeal to a court to do so, right? Rather than the assistance of just say an attorney knowledgeable in estate planning with their irrevocable trusts, which is not always fun because that means more money, more time, more headache, all the things when you are dealing with a court. Again, I'm 𝗬𝗲𝗃 of 𝗬𝗵𝗏 Law, an estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you need assistance in these areas, you can reach us at yourplanningattorney.com. We hope you've learned something new here today. Please don't forget to share and take care.